Item number B, you heard in the city manager's report, this is not ready, so I will withdraw my sponsorship, and that will move us on to item number C, consideration action on approval of order for declaratory judgment with George Anderson. Do I have a motion?
Madam Chair, I make a motion to approve and accept the order for declaratory judgment in the city suit against George Anderson as presented by the city attorney, and to accept as a first read the amendment to the City Code of Ethics procedure for filing complaints and determining cognizable claim described in the order.
There's a motion. Is there a second?
Second.
Discussion by council.
Mr. Powell, I'd like to invite you up to read said item.
Mayor and council, this is really the first time I've had the opportunity to address a council under the new open records and open meetings law with regard to the settlement of a case. These have always been done in executive session, start to finish, and this will be the first time that I've had the pleasure of announcing a settlement. And is this still working? I will tell you that the case has been technically settled for a long time. We had a hearing called on May the 3rd, 2013, in which respondent, Mr. George Anderson, was there representing Ms. Anderson and what amounted to a corporation that had been dissolved by the Secretary of State, which is the one that filed the complaint against primarily Mr. Witts and secondarily against Mr. Emanuel. And in that first hearing, it was announced to the court that Mr. Anderson wanted to apologize to the city of Snellville and to Mr. Witts and to Mr. Emanuel. He stipulated to the court that he did not have a basis to file an ethics complaint and would enter into a written letter of apology, and he did so, under such terms as the petitioner and the court thought were appropriate in order to conclude this matter. Mr. Anderson contends that he thought he had a basis for an ethics complaint at the time he filed it, but has since stipulated to these facts that in fact it was frivolous. The dispute arose as a result of Mr. Anderson representing Corporate Respondent Ethics in Government Group, Inc., filed a frivolous, and when I read this, I want you to know that this is a stipulation that Mr. Anderson has actually signed off on. This is his signature. We received it last Wednesday as a result of the court case being scheduled for a hearing last Friday. So these are stipulated facts. The dispute arose in May of 2012 when Respondent Anderson, purporting to represent Corporate Respondent Ethics in Government Group, Inc., filed a frivolous and unsupported complaint against Tom Witts, a Snellville City Council member. The ethics resolution and conflict of interest provisions of the city charter are in this order hereinafter referred to as the Snellville Code of Ethics. Although the Anderson Group complaints contained 230 total pages, the compilation was incoherent and failed to support any conclusion of unethical conduct. Mr. Anderson stipulates that he had no basis for attacking or publicly humiliating Mr. Witts. He had no reason or desire to publicly damage his reputation, meaning Mr. Witts' reputation, and to the extent he has done so, he respectfully asks that his public and private statements be withdrawn and disregarded. The Anderson Group has now determined and stipulates that the ethics complaint contained no supporting justiciable facts and did not raise any issue for resolution under the Snellville Code of Ethics. Based on these facts, the court finds and declares that the legal principles shall apply to this declaratory judgment. First thing that this order does, and very grateful to have the opportunity to represent the city of Snellville and really every city that has an ethics provision in this type of case. But first thing it does is reaffirm. This is the judge's instruction. It reaffirms the ability of people to speak freely. Free speech is a protected right. It lays that out. What it does after that is it distinguishes the free speech that you can do on the courthouse steps and outside this place with the provisions that govern the ethics of this body. And the discussions when you initiate within that framework a frivolous complaint are totally different. And this order distinguishes those two clearly distinguished provisions of right to speak, but also the right to have a fair and honest hearing and review of a complaint that challenges someone's conduct as unethical. The judge concluded this order concludes in this case, it quickly became clear to city officials that the complaints lacked any factual or legal merit, but the Snellville Code of Ethics had no process for screening even clearly meritless ethics complaints. It is important to distinguish political speech from ethical complaints because the government needs to respond differently to each one. For example, one important difference in the ethics complaint necessarily brings the machinery of government to bear. Free speech is a very different right. The end result of that is this order ends up ordering this. It is hereby declared, ordered, and adjudged that Snellville's Code of Ethics implies that the first step in filing an ethics complaint is presented to the city clerk by hand or by mail. A writing signed by the complainant. So it puts in place. In your ethics provision, you set out a lot of terms that define your ethical conduct, but you don't set out the procedural aspects of how that would occur. Both the amended resolution has been been first read or is being first read with regard to this settlement. It requires a signed written complaint to hold the person filing the complaint responsible. The city clerk then shall forward the complaint to both the city manager and the city attorney, who shall use the criteria enumerated below to determine if the complaint is cognizable. If both the city manager and the city attorney determine that both criteria below are met, the complaint shall be cognizable. Once respondents determined the complaints were without merit, they tried to dismiss them. That was Mr. Anderson. Once he made the determination that the accusations he had made against Mr. Witts were frivolous and false, and he had no substantiation for them, he tried to dismiss them. Respondent enters into this consent order in an effort to assist the city in the future by creating a formal process of summarily dismissing unsubstantiated complaints. It is further ordered, declared, and adjudged that the city code of ethics implies that an ethical complaint must meet minimum threshold of fact and law in order to become cognizable. The minimum threshold includes the following. Each allegation in an ethics complaint must be supported by fact, and those facts must be referred specifically to in the complaint. For each violation alleged, the complainant must specifically reference the provisions of the Snellville Code of Ethics that was violated. If the complaint does not meet this minimum threshold of fact and law, it shall be dismissed and the complainant notified within 3 days of its dismissal. Here, the court stands in the place of the city attorney and the city manager for purposes of declaring the merits of the instant complaint. The court finds that the instant complaints have no basis in fact or in law and are therefore dismissed. Respondents shall be deemed properly notified. It is what makes it possible for the court to come to the conclusions that mark the substantive changes to the code is Mr. Anderson's stipulations at the beginning that there was no substantial basis, even in 230 pages, of any unethical conduct. His stipulation that there was no reason to publicly damage Mr. Witt's reputation. During the communications of this, Mr. Anderson did express a number of apologies, including his a very kind report that seeking Mr. Witt's apology on endorsing the kindness of supporting his employees in the underlying events that Mr. Anderson was trying to use in this case. And so it was a heartfelt, confirmed email of his since what I think to be sincere apology at the time it was made. It is I am in some ways I was was concerned in the approval of this because that language was the language that was approved in its entirety in our executive session. So what I've just read and described to you as far as apologies and frivolous action and his stipulations were always part of the negotiations in this case. After our executive session, Mr. Anderson added the language that you see up on the screen, which is disclaimer language. And in my professional opinion, I deemed that language to not modify what this council had approved in terms of the frivolous nature of the claims, or what this council instructed me to do, to make sure that your ethics provisions are kept unviolated by frivolous complaints. What this appears to do to me is to put Mr. Anderson in a position where he does not want to be prosecuted for violation of any law, rule, or regulation. He's also seeking to disclaim any factual allegations that might constitute a violation of state laws. He also doesn't want the facts stipulated herein to be used by third parties in taking actions for liability estoppel. So all of those are provisions that really are designed by Mr. Anderson to protect Mr. Anderson for what he feels like he has some exposure for having done. And that was not in our instructions from council to punish him for illegal conduct. We were simply trying to correct the wrongs that had been done to council members, and also to create a provision of law here in Snellville that will be a guide to those who have adopted the ethics provisions of the GMA, which you have. This is a certified city of ethics, and with it you adopted what was recommended to you. It had a few blanks in it with regard to frivolous claims. Y'all have boldly stepped up and defended not just your city, but a lot of cities from this type of awful conduct. I'm grateful to have had the opportunity. I do endorse the approval of this settlement, and if there are any questions, I'll be glad to answer them.
Thank you, Mr. Powell.
I have a question. This is the first I've seen this, and just so I understand, he's saying he filed a complaint he had no basis for, and now he wants to say, I'm sorry, and go home.
Yes, sir.
Is cut to the chase. That's what we're talking about here, that the whole complaint was baseless from ground one, and now he's decided that he shouldn't have done what he did. Okay.
Additional questions?
Thank you for working so hard at this. I understand that this took a lot of time and effort. You know, I really like our city manager, but you know, I could really never see into the future, especially about the fact that when we have an ethics situation that would require a city manager or an attorney or someone without a formal board to be able to resolve such situations like that, that can raise a lot of discussions in my mind. Simply handing out a pretty important case just like this one to two individuals to hash out, that I have an issue with, and I will probably not going to vote. I will not vote for this tonight because of that one major issue. The fact that decisions can be done between emails, possibly in person or phone call, without a formal board. Again, don't get me wrong that I'm saying that you don't know what you're doing, neither does he, because I trust your opinions and decisions, but what happens tomorrow is my biggest obstacle that I need to see through. Those are my comments. Now, how would you fix that, I guess, as part of this resolution, to be able to predict a formal future fix, assuming that you don't exist, he doesn't exist, I leave, everybody, so we have a brand new, so how would that is going to work?
I think I can relieve you of that concern altogether, Mr. Sabah, because the adjudication of the merits of an ethics complaint will always go to this body ultimately, or to the superior court. And so there isn't anything about the modification or the court's order that changes who hears an ethics complaint. It's only in that initiation process of a complaint that the city manager and the city attorney make a preliminary ruling as to connecting up the dots, the code with the facts, to make sure there's something for this council to hear. In this case, there is nothing. In the accusations, there is not one iota of link between your ethics provision and the accusations that were made. And when that occurs, it lets you get rid of that immediately and instantaneously, without further hearing, and it really avoids the humiliation, I think, of the battle that goes on over these things, because y'all have experienced that. The accusations that were flying around the council meeting room while Mr. Anderson was here were harsh and vicious. And so that's the kind of environment in which you get accusations being made. And the question is, should somebody be able to come in and make ethical complaints under your ethics code without having a claim that has some basis? And it's that. And so it's just in the preliminary stage. Now, if a citizen or a council member were to disagree with the preliminary ruling, you can always go to the Superior Court, which you can start an ethics complaint under your charter in the Superior Court. And so you're not ever barred from filing it. It will just be, it will either be resolved with that summary procedure when it's frivolous, or it'll come before this board. It doesn't change a bit of your duly adopted Georgia Municipal Association Code of Ethics and your ethics city. It doesn't change that. It still comes here. They get a fair hearing. The hearing is here. It's just when the accusations are indeed frivolous that they get summarily dismissed. It's like in the court terminology, it's like the magistrate judge being elevated to hear a motion to dismiss. Superior Court judges don't want to hear frivolous cases. They send it downstairs. This is sending it downstairs when it's a frivolous case, and so that's really what it's designed to do, and that protects you. Really gives a base protection to the members of council that accusations that are made against them have some factual connection to the ordinance. So you can rest assured these provisions will be heard by the council when there is a link between an ethics violation and some measure of facts.
Additional questions for Mr. Powell?
Yeah. Mr. Powell, I want to thank you for going through all that. And, I wish we didn't have to worry about this. I really don't. I talked about this 2 weeks ago. But when frivolous, non-truthful things begin flying around by the hands of others, and understanding that, subpoenas, can go anywhere, and anybody can be called, even members of our own community. It's time that we just take a stand and say, okay, we need to stop it when it hits the door. And I think that's what this does. I mean, we can committee something to death, but the two folks that are going to view this are going to look at it and say, do we need to bring this to council or not? And if like you say, if council doesn't necessarily agree with that, they can still get it. So it really, just gets the ball rolling for either stopping it or starting it. It's all it really does. But, you don't need to come up with, 18 unbiased people to sit on a committee to decide something that it takes two people to decide. That's classic government. Let's figure out a longer way to do it versus a shorter way to do it. So, and I think what's before us is exactly what we need to get those things where we don't have 6 months where we're sitting here waiting on a decision, and we put something to bed as quickly as it needs to be put to bed, because some things just don't deserve that kind of time, effort, and energy, and the cost to the taxpayer, quite frankly. So,
to a couple of points in response to that, Councilmember Howard. First of all, in June, and I reported this to your city manager, the AJC reported that the city of Dunwoody, I believe, it's been $100,000 similarly battling over ethics issues. that's just not the place for citizens' money to go. And so I think there is a protection, as Mr. Sabah says. There's both a appeal right that comes with a bad decision by the city manager and the city attorney. That's subject to that review process. And so it's not like we ultimately decide the question. You know, we can certainly make errors and they can be corrected. The citizens are not barred. But ethics complaints are very different from free speech and political talk. And, for that reason, this does change the very nature, puts it back there. This is really when somebody, it can be a city attorney, it can be a city manager, it can be a member of council, does something that really challenges the ethics. They usually are used when somebody's taking money, taking bribes, violating a criminal act. When you see it, you know it. And it is really not for entertaining somebody from Rome coming down and throwing around paper that he received anonymously, according to his own statements to me, trying to disparage somebody, which he obviously regrets doing himself. So.
Mr. Powell, I have a couple questions. This case that was filed with City of Snellville was the petitioner. George Anderson, Marilyn Anderson, Tom Witz, and Dave Emanuel are all respondents. Is that correct?
That's correct.
And Mr. Anderson filed another ethics complaint against Councilman Witz and Emanuel a couple of weeks ago. Does this resolve that issue as well?
I'm assuming that it does, Mayor. And the reason I assume that is his signature comes after that time period. But the court is going to have a follow-up hearing on this matter. And so I will know for sure at that point. I lumped them together because it had to do with the pleadings of the case, and really the pleadings of this case are pretty self-explanatory. The City of Snellville has a complaint, declaratory judgment for construction of its ethics complaint, and although the group as a whole did not vote in favor of giving me permission to initiate that action, I believe it was a 4-2 vote. But with that, there was no dissension among council or difference of right when it came to the issue of interpreting the code. It was a action where all participants were on the same page. As we've had legal issues and ethics issues come up, there are times when there are divergent interests between council members and the city itself. And in this case, there is no divergent interest that I'm aware of when it comes to the actual prosecution of the declaratory judgment. The divergent interest comes into play when it comes to the consideration of what the individual council members, the individual respondents, which were named in their capacity as respondents with a material interest. The distinction would be they have cross claims that they have filed against Mr. Anderson that the city is not involved in for different claims. And so those are not things that I participate in or are governed by the settlement that's before you. So that's really where the distinction is. They had to be notified, as we've done with others in the past. When your interests diverge to a different issue that's not a city issue, you have to go seek your own counsel. They've done that. That's why the case is styled the way it is. It's not a divergent interest in the declaratory judgment. We spoke as one, and so far as I know, we've continued to speak as one on the issue of clearing up the frivolous nature of the claim, and also protecting those who sit on that bench from unauthorized and unworthy ethics accusations.
I don't believe we actually got a motion. Does someone have a motion on this? You did? I thought you turned it over to Mr. Powell. Did you make the motion? I apologize. Okay, I apologize. Any further discussion? Seeing none, I'll call the question. All those in favor of the motion as previously stated signify by raising your right hand. That's 4 in favor. All those opposed? That's 2 opposed. The motion stands approved. That now brings us to our council report.